Okay, please raise your right hand. You solemnly swear from the testimony about to give this to be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
All right, thank you. And you may proceed on the warrant.
Your Honor, on September 25th, 2023, about 2 a.m., in the area of 13th and Grove, when they observed two male subjects riding the bikes in the area. Officers noted that the bikes did not have any visible lighting, at which time they made contact with defendant number one, later identified as Mr. Haas, and defendant number two, Eugene Francis McMillan. During the investigations, officers learned that the defendant had defendant number one had several outstanding unconfirmed warrants for his arrest. Officers reported that the defendant number one then attempted to flee on his bike, where a physical struggle took place.
I'm sorry, Detective. Detective, sorry, I'm sorry. I don't know what's going on. Oh, no, because I unmuted myself here. Detective, I'm going to actually indicate this also. I'm going to call the matter of Mr. Haas as well, since they're co-defendants, so you don't have to re-sign on the record for that. So the court's also indicating this is the matter of the state of Michigan versus Kenneth Haas, 232137. I'm sorry, you may continue, counsel.
Your Honor,
Detective, yes.
may I say something? I'm going to be representing both.
I understand, but right now I'm just having him swear on the warrant.
I understand, but could he identify the defendants instead of one and two? I want names. So.
Okay, counsel, your appearance for the record, please.
Richard T. Serrano, P3 3828, appears in MIDC counsel on behalf of both defendants for arraignment purposes only.
Yes, I believe the detective did indicate defendant one and defendant two. But detective, if you can indicate who is defendant one again, please.
Your Honor, defendant number one is Mr. Kenneth Milton Haas. And defendant number two is, we have sitting here, Mr. McMillan.
Okay, all right, is that sufficient, counsel?
Yes, Your Honor, thank you.
Okay, all right, sorry, detective, to interrupt you. I just figured for the flow, it would, for both defendants, so you wouldn't have to re-sign on the warrant for him as well, so.
Your Honor, I wasn't sure how you wanted me to go about it, so.
Okay, that's all right. All right, so you may continue on you may continue, detective.
Your Honor, if it's okay with you, I start all over. I can start from the beginning.
That's fine, that's fine.
Okay. On September 25th, about 2 a.m., officers were patrolling the area of 13th and Grove when they observed two male subjects riding bikes in the area. Officers noted that the bikes did not have any visible lighting, at which time they made contact with defendant number one, identified as Kenneth Milton Haas, and defendant number two, Eugene Francis McMillan. During the investigation, officers learned that defendant number one, Haas, had several unconfirmed warrants for his arrest. Officers reported that defendant number one then attempted to flee on his bike, where a physical struggle took place, and defendant number one began actively resisting officers and resisting their verbal commands to stop. The defendant again attempted to flee officers on foot, but was subsequently taken to the ground by officers, where he was tased, where a taser was deployed, and the defendant number one was placed under arrest. Defendant number one, Haas, verbally advised officers that he was in possession of crack cocaine, which was later located in a sock worn by defendant number one, Mr. Haas. The recovered cocaine later field tested positive and weighed in about 0.84 grams. During the physical struggle with defendant number one, Mr. Haas, Officer Stathakis injured his left elbow, where he sustained a laceration and bruising. Defendant number two, Mr. McMillan, was cited and arrested for loitering where drugs were used and sold. Both defendants were then transported to the station where they were booked and held. Officers later reviewed the incident on their body-worn cameras, where it was discovered that defendant number two, Mr. McMillan, had discarded a crumpled piece of paper on the ground while officers were physically fighting with defendant number one, Mr. Haas. Officers returned to the scene and located the discarded crumpled paper, where it contained crack cocaine, which did field test positive and weighed in at about 1.24 grams.
All right, thank you. Upon examination of the complaining witness, the court finds that the offenses charged as to both defendants were committed. There's probable cause to believe that the defendant committed those offenses. All right, and Mr. Serrano, your appearance, please.
Do you want to
This
take
is-
both defendants together?
Well, no, because of the close quarters, we're going to just arraign each of the defendants separately, but for the swearing on, I called both cases.
I understand. So
This
we
is defendant Mr. McMillan.
All right, thank you. Your Honor, good afternoon, Richard T. Serrano, P33828. Today, Your Honor, I appear as MNDC counsel on behalf of Mr. McMillan, who's in custody as MNDC counsel for arraignment purposes only. And please state your name, sir.
Eugene Francis McMillan II.
All right, good afternoon, sir. Okay, and counsel as in the arraignment.
Your Honor, just so we're clear, I'd like a formal reading as to Mr. McMillan because I heard something that I didn't see in the file, but could we have the charges read, please?
All right, the complaint alleges on September 12th. Did you say September 25th or September 12th?
It should be September 25th, Your Honor.
Oh,
That appears to be a typo on the prosecutor's side, Your Honor.
okay, so we'll have to make sure that that's amended. Okay, and it's alleged on September 25th in the city of Wyandotte. That you did knowingly or intentionally possess less than 25 grams of a mixture containing the controlled substance cocaine. This is a felony charge. The maximum penalty upon conviction is not more than 4 years in state prison and or $25,000 fine. The complaint alleged on the same date and location that you did assault, batter, wound, resist, obstruct, oppose, or endanger Alexander Stathakis, a police officer in the city for the Wyandotte Police Department that the defendant knew or had reason to know was performing his duties. This is a felony charge. The maximum penalty upon conviction is not more than 2 years in state prison and or a $2,000 fine. Consecutive sentence may be imposed under state statute if the assault was committed in a place of confinement or for another violation arising from the same transaction. And so, counsel, are you satisfied with the reading?
Yes, Your Honor, I heard something about loitering where drugs are used in the swear to. That's a misdemeanor.
Well, counsel, there may have been a ticket provided for that. Let me, hold on.
That's correct, Your Honor. Mr. McMillan was cited for the loitering where drugs were used and sold, which brought him to the station. He was arrested on that. And then they later viewed the body cam video, which showed that he discarded the cocaine at the scene while officers were scuffling with Mr. Haas.
Okay,
So there are 3 charges for Mr. McMillan.
well, there are 2 felony charges and then yes, then there's a misdemeanor that, but we don't seem to have that file.
I didn't see it, that's why I
We're only
didn't
doing
invite my
the-
client into it.
We're only doing the felonies as to these 2, so perhaps he's going to be getting a new date, he'll get a date on the other one.
All right. So I'm clear now. The 2 felonies we're here for arraignment today. I'll wait for reading stand you. Excuse me.
Well, I've already done the
We
reading,
had
so,
the
okay.
reading, Your Honor. I'm sorry, it's a long day.
Oh, yes, it is. Fading out.
So we stand mute, Your Honor, to the charges presently. read by-
Okay, the court, sir, you have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. And in fact, you've had an opportunity to speak to an attorney today, correct?
Correct.
Okay. You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
Yes, ma'am.
The court's going to enter plea of not guilty on your behalf. Schedule this matter for probable cause conference on October 5th at 8:50 a.m. And counsel as to bond.
Your Honor, my client is single. He lives with his girlfriend presently. He is working full-time. He works at a firm called KBS. They do rehabilitation of tires and parts for cars. And Your Honor, he tells me he's not on probation or parole. It does not have any matters pending that he's aware of. So if all those things comport with the court's assessment, then we'd ask for a personal bond or a bond we expect to post.
Okay, I thought your name was familiar and I thought you looked familiar, sir, and I reviewed your criminal history and I see why. And do you still live at your address in Riverview, sir?
Yes, ma'am.
And if you were to test today, sir. Sorry, what's that?
I'm currently under a chapter 13 in that house. That's the only place I got to live.
Sir, if you were to test today, what would be detected in your system?
Nothing.
Nothing at all.
Shows you clean.
All right, in reviewing your criminal history and the nature of the charges, the court has some concerns. Detective, would you like to address bond?
Your Honor, just to clarify with the court, and not to confuse everyone, but I believe that Mr. McMillan is defendant number 2 listed on the warrant. So he is only charged with the 1 count of controlled substance, possession of cocaine. And Mr. Haas will be charged with both felony charges.
That is correct. You are correct. So, Mr. Serrano, when I went on to count 2, that's only against Mr. Haas.
All right, Your Honor.
Yes.
Thank you.
All right, thank you, Detective. And so as to bond,
Mr. McMillan, his criminal history is not as lengthy as Mr. Haas's. Just to reassure the defendant's next court appearance, I recommend a $500 cash bond, Your Honor.
I'm sorry, I didn't hear that. What bond?
$500 cash bond, Your Honor.
Okay. All right, the court does find that's an appropriate bond, given Mr. McMillan's criminal history and the charges here. Oh, and I'm sorry, counsel. There. He also has a civil infraction for a bicycle on a roadway.
I didn't see that. We
Okay.
deny responsibility.
And the court will indicate a $5,000 10% bond, not to possess or consume any alcohol or drugs unless prescribed. And we'll see you back on October 10th. So we are on the record in the matter of the state of Michigan versus Kenneth Haas, 232137, and the city of Riverview versus Kenneth Haas, 201462. And appearance, counsel?
Your Honor, good afternoon. Richard T. Serrano, P33828. I appear today as MATC counsel for arraignment purposes only on these matters. Please state your name, sir.
Kenneth Haas.
Okay. All right, and counsel, as to the arraignment for Mr. Haas. Well, actually, just for the record, do you want to address the fact that you're representing both defendants? Would you like to address that, counsel, with?
Yes, I'm addressing the court as to both defendants, Your Honor. I appear as MATC counsel only for arraignment purposes, and I will not be the attorney of record. There may be a conflict of interest, Your Honor, so I would ask that 2 attorneys be appointed. Of course, I'm not on the felony list, so I will have neither one. But Your Honor, my client understands that for arraignment purposes, I'm addressing both co-defendants.
Okay. And do you waive any potential conflict, Mr. Haas?
Yes.
Okay. All right.
Your Honor, I would like to call a meeting on the 201462 because my client was confused on that one. With
On the
the
what?
felonies in these charges.
201462. Oh, he failed to appear for a sentencing on that matter.
Oh, so it's a warrant only.
That's a warrant only, yes. He
Okay.
failed to appear for a sentencing on disorderly conduct or disturbing the peace, which is an amended charge back from 2020.
All right. We wait for him reading, that's all that matters, Your Honor. He heard the readings before and I went over the other felony matters with him.
Okay. All right, the court is going to waive the formal reading. Sir, you do have the right to have an attorney if you cannot afford one, the court will appoint one to represent you. And in fact, you had an opportunity to speak to an attorney today, correct?
Yes, Your Honor.
Okay. And you also understand that you have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
Yes, Your Honor.
The court's going to enter a plea of not guilty on your behalf. Schedule this matter for probable cause conference October 5th at 8:45 a.m. And counsel as to bond.
Your Honor, it's already been stated, my client has warrants, he has a significant criminal history. Your Honor, he stated to me quite clearly, he wants some drug treatment. In the past, he's been, had outpatient treatment, but he wants to continue some treatment when he can get it. So we ask the court to consider that in fashioning his bond, Your Honor. He's separated from his wife, he supports no children, he's 38 years old. And he does have a full-time job, but obviously these matters are gonna have priority, so we ask the court to consider.
So you earn $250 a month for your full-time job?
That's because right now my work's slow for this month and it's like 1-2 days a week right now, but after October hits, it'll shoot back up to 7 or 6 days a week, and then I'll get $120 to $150 a day.
Okay. Detective as to bond. I'm sorry, Detective, your name for the record. I don't think I have you on the record for this one.
Good afternoon, Your Honor. Detective Joseph Carr, One Dock Police Department.
Okay. And as to bond, does Mr. Haas have a current case with us from February?
Let me check, Your Honor. I'm not completely aware of it. There may be something on the CCH that I have not seen.
There is. It says from February 20th, felony dangerous drugs weren't requested. I just wasn't sure if we had received that back yet or not.
Not that I'm aware of, Your Honor.
That's it.
Okay.
I was cooperating with us.
I can't understand anything you're saying, sir.
Mr. Haas, don't talk about any of the facts of any case that you're charged with.
Okay.
It looks that there's no judicial segment on that charge, Your Honor. Again, I did not check that case out, so.
Okay, and then. Okay, and so Detective as to bond. I mean, yes, bond.
Your Honor, reviewing the defendant's criminal history, he has the outstanding warrants. I do think he's a bit of a flight risk, so I'm gonna recommend a $1,000 cash bond of the 2 charges and to reassure his court appearance and then a GPS tether, Your Honor. He did fight with the police and try to run from them. So, I mean, there was the intent to evade at one point or another, so.
I was just scared.
Okay. Sir, you failed to appear in 2020 for sentencing and you're disturbing the peace. And then there's another matter from February of 23 for the same type of charge here today for a dangerous drugs felony. But I feel like you've been here since 2020.
Your Honor.
What'd you say?
I don't think I've ever been in front of you, Your Honor.
Well, you have, because I arraigned you and accepted your plea back in 2020. So, but here's where the court's going to order for bond. The court's going to state that based upon defendant's failure to appear on 201462, the fact that he has a criminal history, and that there was another charge where there was a warrant requested for the same possession charge here. The fact that the allegation is that Mr. Haas attempted to flee the police, the court has concerns that defendant's going to appear in court. The court does find a $10,000 10% bond request is appropriate. In the event you co-sponsor GPS tether to the Wayne County Jail, and you're not to possess or consume any alcohol or drugs unless prescribed, what would be detected in your system right now, sir?
Cocaine.
All right, and then as to the 201462 matter, based upon the defendant's failure to appear previously, the court's going to indicate a $5,000 10% bond. The warrant is recalled, and you will set this matter for sentencing on October 5th. Well, shoot, I do October 5th, that's too. We'll do October 12th for that sentencing date. And then, sir, you're going to be interviewed by probation, re-interviewed, because I'm presuming things have changed in the last 3 years. Okay, thank you.
Right up to the podium.
Okay. We are going on the record in the matter of the city of Wyandotte versus Gerald Parker. Also known as Charles. Hold on, sir, I'm getting to that. Also known as Charles Parker, 232-114. And counsel, your appearance for the record, please.
Your Honor, Richard T. Serrano, appearing as MIDC counsel on behalf of my client who's presently in custody. I appear for the client for arraignment purposes only. Please state your name, sir.
Charles Andrew Parker.
Okay, and I recall you, Mr. Parker, because I recall, I think that you said that your birth certificate says one name, but you're.
Sent me to
Sorry, what's
rehab.
that?
He sent me out to rehab in Detroit. Bingo. Lake Ridge. I completed that in March.
Well, okay, but sir, I don't think that you kept a lot of stuff with you because now you're back here, where it's alleged you've relapsed. So,
Well, I fell off my bike.
I'm sorry?
I fell off my bike and they came over to me because the sidewalk was.
Don't talk about
My
Sir,
bike.
sir, are you still intoxicated?
No.
No.
I asked him that, Your
I
Honor.
noticed when you walked in, you fell up against the wall. You're not intoxicated.
No, I was sleeping on it and I just got up and I went in for a while.
Okay, counsel, as to the arraignment.
Your Honor, I've advised my client of his rights and all the charges against him. I was involved, everyone would wait for him reading statutes.
Or waiting for a reading, enter plea of not guilty for purposes of the arraignment. We'll schedule this matter for pre-trial on October 10th
Okay.
at 9:45 a.m. Counsel as to bond.
Your Honor, my client lists his residence as homeless. He tells me there is some place that he can go. Friend or relative, I forget what he said, but he's not working at this time. Your Honor, he tells me he's never failed to appear in court. Tells me again, he has no cases pending, not on probation or parole. I leave it to the court's discretion to give him a personal bond or bonding in reasonable respect to those.
Okay, well, the court is familiar with Mr. Parker. Mr. Parker, when did you complete rehab?
October for 4 months and 60 days after that for the two past misdemeanors. One in Wyandotte, the other one is Lincoln Park, I believe.
Okay, and The court finds that a $7,500 10% bond with an alcohol tether to the Wayne County Jail is going to be appropriate. We're not sure where Mr. Parker resides, and Mr. Parker needs some assistance, it appears, with maintaining his sobriety. The court's going to also indicate not to possess or consume any alcohol or drugs unless prescribed. I will indicate, sir, that defendant may be tethered to treatment, may be tethered to alcohol treatment
Been through all that.
through the Wayne County Jail if requested.
Thank you.
Okay, thank you. Off the record. All right, that's our docket for the day.